Hello, everyone. Thanks for joining me for this brief program on estate planning and everything you need to know about how to create a will in Oklahoma. My name is Larry Parman, and I really appreciate you taking a little bit of time. This is not going to be a long program, but an overview of what we've learned about estate planning through the years since forming our firm in 1985. My story about estate planning started years ago when my dad woke up one morning and didn't feel very well. He had a sore throat and he went to the doctor, and the doctor said, "Well, I think it'd be smart if you don't go to work today." And so my dad did what he always did when he couldn't go to work. He went to the farm, and he lived in Northwest Missouri, where I was born and raised. So on the farm, he began the process of getting on the John Deere 4020 and going down the field on the side of a hill and backing into those big round bales, you see along the side of the road, and bringing those up to the barn and getting them all lined up. Well, as fate would have it, the grass that early morning had a lot of dew on it. It was wet. He backed into a bale, turned sideways. The centrifugal force of that very heavy bale, along with the tractor, caused the tractors to slide sideways. And it fell off the edge of a ditch, actually a culvert, a deep ditch. And the tractor fell into the ditch, rolled over on him, and he lost his life that day on the farm where he was born and raised. Now, many of you listening have lost parents, and it leaves a big hole, right? Sometimes it just can't be replaced. So that experience left not only a hole in my heart, but it formed an indelible impression in my mind, even my soul, because my mother and I had to deal with the IRS for 3 years, talking about probate and taxes, going through the courts, dealing with that piece of it, as I said before, the probate piece of it. And so that experience caused me to conclude one thing. If I ever had an opportunity to create my own law firm, I was going to stand in front of as many people, visit with as many people as I could, even across the kitchen table, and share with them the importance of creating an estate plan. So that's my why. Everyone in our firm believes not just in my story and my why, but many of them have had their own experiences, and perhaps some of you had too. So the how and the what deals with how we go about developing a plan for people, and the what is the deliverable, the outcome, if you will, the documentation that reflects exactly what you want in an estate plan. I think a little context here is important because we have many challenges today. We have millions of lawsuits being filed and 500,000 people or more filing for bankruptcy about every year. And 1 out of 4 of those bankruptcies are due to overwhelming medical bills. And again, we understand, and regrettably so, that we have one of the highest divorce rates in the world. And that creates challenges with respect to estate planning as well. Some of you may fall into the category of being a caregiver, sandwiched between an elderly parent and a young adult child, perhaps still living at home, and somewhat dependent upon your financial resources. And that can create challenges. There are countless lawsuits and will contests occurring because of poorly drafted estate planning documents. And we cannot forget this one: the ravages that long-term health care can create in our financial and estate plan. Nursing home costs are out of control. And although none of us want to admit that we may have a nursing home experience, statistics tell us something different. So we have to be concerned about that. You can see on the screen the average cost of nursing homes today across the United States is out of control, and it's causing a problem. It's causing financial disruptions for many families. And then, of course, we have the financial risk. I mean, families are getting devastated with what's going on in the financial markets today. Markets are down. People are afraid. People are wondering, golly, am I going to run out of money before I run out of life? And nobody likes to think about that, but we have to plan for it. And then, of course, we cannot forget the context of the coronavirus and the issues that has created within families the past few years. And we have the domestic changes. We have international events, the war in Ukraine, We have tax legislation. The news headlines are filled full of all kinds of things that can depress us beyond belief sometimes. But here's what I want to share with you today. Let's just focus on what we can control. Many of those things are out of our control. What we've learned through the years is that comprehensive estate and financial planning is no longer optional, it's mandatory. And yet people don't plan. They keep putting it off, maybe not because of a lack of knowledge, but rather because of a lack of comfort with the knowledge they have. And that lack of comfort may be triggered by misinformation and disinformation. There's so much out there. I kid a little bit about this, but you could go to 10 different law firms and ask them the same question about estate planning, and you'll get 12 different answers. So we know there are continuous changes in the law. Things are moving quickly. Family dynamics are changing rapidly. So people don't plan because they get a little bit confused. And then there's this internal chatter in our mind that this is too hard, it costs too much. I don't want to have to wrestle with these decisions, and I don't know where to go to get help. That confusion causes us to procrastinate. We just keep putting things off over and over and over. So here's what I want to share with you. Estate planning, comprehensive estate and financial planning is no longer optional. It's mandatory, something we have to get done. Now, when we visit with people, they talk to us about these objectives. The first is they want financial security. And as I said before, not run out of money before life. Everyone hopes to leave a little legacy. Everyone wants to preserve their lifestyle. And the ongoing question is, will we have enough to last? They want to pass on their hard-earned wealth without government or court interference, and they certainly want to keep taxes and fees at a minimum to the greatest extent possible. And as I mentioned before, more and more people are concerned about this nursing home issue and those crushing medical expenses. Predators and creditors, scams are becoming much more of an issue than they were a few years ago. We have clients calling all the time telling us they were victimized yet again one more time. So we have to be careful of that. Obviously, we don't want family members fighting over money. We'd like to preserve the harmony within our families to the greatest extent possible. No one wants to tear their family apart over the inheritance they might receive. So again, if we get started today, I would like to assert that estate planning is all about asset protection. And different people have different levels of asset protection that they require or need or want. This is a chart that I drew for clients for years. And if I could draw it out for you, and if I knew more about this program, I could do it in real time. But all of us have assets. And there at the bottom, you see, most of us have heirs or certainly beneficiaries we hope to leave our assets to or our inheritance to. And then if you look on the right, we have the issues of what occurs during death. We have probate. And people get concerned about probate because of 4 reasons. The time it takes to complete it, not unusual for a year to 2 years. The money required to complete it in the form of attorney fees, court costs, and executor fees, and so forth. And that could be 3 to 5 to 6, 7% of your estate, the gross value of your estate. It's possible to have multiple probates if you own property in more than one state. Probate is a matter of public record, and then we have the issue of taxes as well. And then during our lifetime, and I would submit to you that life care planning, at least from our point of view, is equally, if not more important than death planning, because we have multiple health issues confronting us today. Years ago, well, for example, both my grandfathers died when they were 65 of heart issues. Thank goodness I've avoided that. But today, with stents and bypass surgeries and so forth, leading to a longer life, that also invites in all kinds of other issues you see on the left there, the Parkinson's, the Huntington's, the Alzheimer's, et cetera, sometimes resulting in a nursing home experience and the cost of that. We also know that there's litigation from people who are driving and have accidents, people getting sued all the time. It's a very litigious society. So rather than those assets move straight to the heirs, those two sides of events that can occur block off the transfer of the assets to the heirs in a timely fashion. And that ends up costing money to resolve prior to the heirs receiving any money. So the first thing that's important for those of you watching is to try to the greatest extent possible, get clear on what you want to achieve with your estate plan, and specifically where you want your assets to go, to whom you want them to go to, and when you want them to be received by your beneficiaries. And finally, answer the question, well, who's going to manage and oversee that process? So again, identify your wishes, determine what assets you have, identify your beneficiaries, when do you want them to receive the money, and who's going to oversee that process. Now, some of you, and hopefully there are some who are younger adults, and by the way, I can't stress enough the importance of you having a plan as well. It's not incumbent upon you to wait until you're 60 to create an estate plan. If you have minor children, it's critical that you create a plan that identifies guardians for your minor children and the disposition of assets you have if both you and your spouse happen to be killed in a common accident, go to a party, for example, and never come home. If you fail to identify those guardians and you fail to identify how you want your assets managed, it invites an argument. Sometimes between grandparents that get along beautifully, but for this, because both of them may want to provide care and well-being for your children, and yet you may have different feelings. You may feel like your values are more closely associated with another couple, friends that you know that you may prefer, oversee the growth, maturity, and the development of your children. So that's critically important too. So again, I mentioned this before, but it's important to decide who you want to be in charge. If you're creating a will, that would be your executor. Now we refer to that person as a personal representative. They are the person responsible for gathering your assets. Really important to keep people informed, because otherwise it may be a scavenger hunt to find everything you own. But once those assets are identified, then they're valued. Final payments and bills are taken care of. The final tax return is filed. If you're older and receiving Social Security, for example, those benefits would be terminated. It's essentially the process of wrapping up your estate and wrapping up your financial life. But it's important to choose somebody who you have the ultimate trust with to oversee that process. If you fail to designate somebody by failing to plan, the court's going to appoint someone for you. And let's be clear, if you do not have a plan, your state has created one for you. That's called by the laws of intestate succession. And believe me, if you are a surviving spouse, you're not going to be happy with that plan in virtually all states. So after you're clear about your wishes and who you want to oversee the management of your estate, then it's time to legally document them in the form of perhaps a last will and testament. Now let's take a look at the elements of a will, and I'm going to speak specifically about Oklahoma. This is true in virtually all states, though, with minor exceptions. The first is you have to be 18 years of age and you have to be of sound mind. When people sign wills, we go through these formalities with them and ask them if they understand they're signing their last will and testament. And we have a little fun when we ask them if they're 18 and of sound mind. We usually get some funny responses from that, but nonetheless, we ask them to take that question seriously and answer it in like kind. So what about the format of the will? Can it be handwritten? Absolutely. In Oklahoma, you can have what's called a holographic will. It has to be in writing and it has to be signed by the hand of the testator or the testatrix, the person actually creating the will, and dated. People get into trouble with holographic wills, though, because there's a lot of confusion about it. Well, what if it's part typed? What if it's typed and then signed by the individual, and so on and so forth? And unfortunately, that just doesn't work very well. And it also leads to a lot of confusion because there may be conflicting documents out there. There may be beneficiary designations that conflict with the holographic will. And so you want to be sure that You go through the formal process of having a typewritten will that's signed by you, witnessed by two people who are not related and not named as beneficiaries in the will. And so that it could be what's called self-proving, it should be notarized as well. And that would keep us from chasing down witnesses 20 years, 30 years down the road, if and when that will became active. So now the will's created. What does that mean? Well, remember, a will does nothing for you until you pass away, so it provides no life care planning at all if you become disabled or incapacitated. It's important to keep that in mind. But let's say you do have a will in place. Does that will transfer all of the assets you own to the beneficiaries you outline in the document? The answer is no, because there are some assets that transfer to designated beneficiaries by a contract with that financial vendor. For example, those would be IRAs or 401ks, any type of a retirement type plan. It might be a 403b or even a 457 plan, deferred compensation. Any account that has a designated beneficiary will transfer to your identified beneficiaries in that contract and supersede the terms of your will. Let's let that sink in for a minute. Any of those three types of assets will transfer according to the terms of the beneficiaries you identify in the contract with the financial vendor and will supersede the terms of your will. Also, if you own property jointly with rights of survivorship or as tenants by the entireties between spouses, those assets will transfer to the surviving joint tenant by operation of law, and again, will supersede the terms of your will. And one thing I should mention here is that any asset, I call this the rule, any asset that's titled in your individual name will go through probate. So let's be clear, you can have a will, it's important to have one, but if you transfer assets to your beneficiaries through a will, those assets will go through probate in order to have ownership vested in your beneficiaries. I'm going to say that another way. Some people get very confused about this. They think that if they have a will, there's no probate. Let's start with how the asset is owned. If the asset is owned by an individual, by you individually or anyone else, those assets will go through probate and they will transfer to the parties you identify in a last will if you have one, or if you do not have a will, by the laws of intestate succession in the state in which you reside. So there are a few limitations, and I think a number of them, to just having a will. I've mentioned before, those assets will transfer and go through probate. Don't have to worry about that. I'm going to say something a little different in a different form, and then I'll come back to it than what's shown on the screen. People object to probate and are dissatisfied with it because of 4 reasons. First of all, the time required. Not common for it to take 1 year to 2 years. They're frustrated with the money that it costs, and I've mentioned both of these before. Not unusual for probate to cost 3 to 8% of the value of your gross estate. If you own property in more than one state, and those properties are owned in your individual name, you will be required to go through what's called an ancillary probate. So you'll end up having 2 probates and not 1. And then finally, probate is a matter of public record. So you see those on the screen. And you see in the lower right-hand corner what I mentioned earlier, that a will does nothing to protect your assets or protect you during your lifetime if you become incapacitated. So those are some of the concerns that people express to us about having a will alone. So what might we do to overcome that? A will is just one element or one step in a comprehensive estate plan, a plan that hopefully will allow you to accomplish your goals. There are additional documents you should consider. For example, a living trust. Think of it this way. All of us have a probate estate over here. What many people choose to do is set up a non-probate estate so that the assets that transfer to their beneficiaries will not have to go through this probate estate. And they do that by creating a living trust. And then they transfer all their assets into the trust because that trust is a contract and will only transfer and control assets titled in its name or assets it receives through a proper beneficiary designation. In addition to the trust, which itself has many life care protection provisions in it, it's important to have a power of attorney for both financial purposes and healthcare purposes. On the healthcare side, you'd certainly want to have an advance directive. That would be the document that would indicate to medical providers how you want, what treatment, let me say it that way, what treatment you would like to receive in the event that you're either terminal, perhaps you're persistently unconscious, or you have what's referred to as an end-stage condition. And the key question there is, if you're in one of those three conditions, according to two physicians, do you want to be kept alive on a machine? Do you want to be intubated? You want to be put on a respirator? And the advance directive will give you the opportunity to describe to the medical community exactly what choices you're making. By law, the medical community cannot release information about your medical treatment or condition to anyone because of the privacy laws, unless you sign a HIPAA form authorizing them to do so. So those documents are critically important as well. So now the question comes up, well, how do you know what's best for you and your family? Well, getting great legal counsel, competent, experienced help is critical to this step. Because for many people, looking at my handwritten chart again, most would like to avoid probate and all the elements of it, minimize the taxes, take care of some of the life care issues that come up. What happens if you become incapacitated? Are you protected? Does your surviving spouse have the proper legal documentation to use your own money for your own care and well-being without going to court and opening a living probate and asking a judge's permission to spend your own money for the care and well-being of your own spouse? That makes no sense at all. So again, I'd like to assert that estate planning is mandatory today. Now, and only now, with that high-level overview, let me share with you just a little bit about us and what we do. First of all, my name is Larry Parman, and I'm the founder of Parman Easterday. Our practice focus is exclusively on estate planning. More on that in a moment. I'm a certified estate planning specialist with the National Association of Estate Planners and Councils. I've had a little bit of public service in my life. I spent some time as Secretary of State and Secretary of Commerce in the state of Oklahoma. Our firm is a member of the American Academy of Estate Planning Attorneys, as well as the National Elder Law Attorneys. We are also registered investment advisors. We wear two hats. We believe that integrating your estate plan and your financial plan is very important. And I've taken some time to write some books. You see the three listed right there, Guiding Those Left Behind in Oklahoma. That deals with how you wrap up an estate, the settlement process. I was asked to contribute a chapter in a book on financial and investment planning, and my chapter deals with retirement planning and asset allocation specifically. And then a book called Estate Planning Basics. It's a crash course in safeguarding your legacy. My most recent book, which was released last year, is The Straight Shooter's Guide to Estate Planning. And that's really important. It's a simple, straightforward description of the estate planning process and the issues that may be important to you. Again, our focus as a firm is estate and tax planning, along with elder law issues. We do planning for business owners. And again, it's important, we also handle the investment management and financial planning of clients as well. It's an integrated approach, coupling the financial, tax, and financial planning with the legal side as well. We handle the legal side and the tax side through the law firm, and we also own a registered investment advisory firm called Intrepid Financial Advisors. We're a little bit different, we believe, because of our experience and the comprehensive approach we take to estate planning. We work off of a fixed investment, not an hourly billing rate. We think that's important for you. We always get our work done within 30 to 40 days. And again, that's important because these things can drag out forever. And rarely, occasionally they do, because you may have more complex issues that you want to wrestle with and decide upon. And sometimes we don't get that deadline quite met, but we work really hard to accomplish that. And every time a client walks out of our front door, we want them with a big smile on their face. And we want them to have the best consumer experience they've ever had. It's a long-term relationship, us staying in touch. This is not a transaction for us. So through newsletters, both in the mail and electronic, we stay in touch with you multiple times a year. So what might be your next steps? Well, here's what I can assure you. I've done this a long time. At the end of your life, there will be a conversation, probably around your kitchen table. One conversation by your children, by your grandchildren will be, oh my word, what a mess. How are we going to take care of this? Does anyone know what mom and dad's assets were? Do we have any idea who's going to be responsible for overseeing this? Do we have to go to court? Is this going to require a lawyer? If so, well, who are we going to hire? I'm confused. I don't have time to do it. I have 2 children of my own. I have a job. I'm busy. And so the conversation continues in that vein. The other conversation can be, we're so proud of mom and dad. There may not be all the answers here, but we have a roadmap. We have a way to keep taxes at a minimum. We have ways to avoid probate. We have ways to deal with this. We know who's responsible by what they've indicated in the document. We know where the assets are. Because mom and dad were prepared, we're prepared. One of those 2 conversations will take place, and there will be footprints left in the sand based on those conversations. So my mother and dad did not have a plan, and you heard what happened. So don't be like my family. Choose a different route. This is not the time to bury your head in the sand. This is not the time to procrastinate. This is the time to be a hero to your family. So here's what I'd like to invite you to do. If you have an interest in finding out more, you can call our office, and you see the number there, 405-843-6100, and set a complimentary consultation. If it's complimentary, it means it's what? Yes, it's free. But realistically, my time's important, your time's important, so we want it to be meaningful. During that consultation, it's important that if you're married, both spouses attend. But it will be a conversation to answer your questions. We'll ask some questions. We want to get to know you. We want you to get to know us. We'll talk about what you've done so far, what you'd like to accomplish, what the obstacles have been, and what's going on in your family, how your assets are titled. We'll just go through the whole conversation. And through that, we'll come up with a plan design and an action plan for you to get it implemented. We'll talk about the investment required, and you'll know the fixed investment required before you have to say yes or no. But once you say yes, I'd like to proceed, I like your approach, I like the way we've designed the plan, then we move forward and we create a roadmap and set our timelines to accomplish your planning. So I want to thank you for taking a little time to allow me to share a quick overview of estate planning. We hope you've enjoyed the program, and we look forward to hearing from you. Again, my name is Larry Parman, and we can be reached at 405-843-6100. You have a stunning day, and I look forward to visiting with you soon. Thank you.